Good evening, everyone. It is Tuesday, October the 2nd, and this is the continuation of the public hearing for zoning case 2018-12P2, continued from September 18th, 2018. I just want to remind everyone, as we had stated in earlier hearings, that we'll do a swearing in a second for anyone who wishes to speak. So you will be under oath when if you do speak your position. But we do insist that this be done in a civil, orderly fashion. Everyone is entitled to speak their mind without being harassed or abused in any way. So we please ask that everyone be civilized and polite and allow people to speak their piece. So at this point, I would ask for anyone who will be testifying this evening to please stand, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in these proceedings, so help you God?
I do. I do.
When we continued this hearing on September the 18th, Mr. Vera was in the process of his presentation and witnesses, and I would invite him to come forward and continue.
Thank you, Mr. Connor. Before calling the witnesses, I would like to discuss with you a few housekeeping measures that I think might be important for the good of the hearing. And first of all, it occurred to me that perhaps collectively we have not been as formal as we might have been with exhibits. I think that's probably true of everyone at this hearing. Part of the reason was that when I arrived the first night, I inquired of the court reporter whether she was employed by the township or by Mr. Barrett, since she frequently worked for him. And she said that she was employed by Mr. Barrett. For that reason, I did not give her exhibits as they were introduced by witnesses and didn't ask her to number them and so on. I think it was into the second night before we realized that she was employed by the township. And I think the exhibits might have, I made a point of giving the exhibits to Mr. Bickford, thinking that in the absence of the fiscal officer or other staff member, that he was the person who would most likely keep the exhibits. So what I would like to suggest to you is I put together a list as best as I could remember them of the exhibits in no particular order, and I would ask that you take a look at them, and at some point, either opposing counsel or someone else may want to add to that list or correct the list of exhibits, but I think we need to do a little housekeeping, so I'll pass that around. Second housekeeping matter is that I want to draw to your attention that subsequent to our last session, that is after September 18th, the applicant CIG did a filing, which you should become aware of. And we had a discussion about the right-of-way width and so on of Kenwood Road. And because it's a major arterial, the county requires that there be 120-foot wide right-of-way, and today there's only 88 and a couple inches beyond that. So that means that in order to, and the county typically requires dedication of that additional right-of-way when development occurs. And so that would have meant 88 from 120, and 32 feet, half of which is CIG's responsibility. They would have had to dedicate another 16 feet of right-of-way, which brings the right-of-way right up to where the face of the building is, approximately, today, on their plans. And of course, you have a setback requirement for another, I think it's 12 feet. So they could not proceed, even if you approve the plan that you have before you tonight, unless the County Regional Planning Commission approves their request, which they filed after the last hearing, for an exemption from that 120-foot right-of-way requirement. I would like to pass out for everybody's benefit a copy of the application as well as the Regional Planning Commission's schedule. This will not come before the Regional Planning Commission until their November 1 meeting. So it seems a little cart before the horse to consider approving a site plan which may be undoable pending the outcome of the Regional Planning Commission hearing on November 1. They are certainly prepared to bring Mr. Flume back at the appropriate time for discussion about what this all means. I don't know how you would prefer to handle that, whether you want to wait till later on and have Mr. Wiley, the applicant's traffic engineer, address this question, or whether you want to have Mr. Flume, but we would like the opportunity, if Mr. Wiley, for whatever reason, is not calling us a witness, to bring back Mr. Flume to address this issue for you. Also, finally, in the way of housekeeping, we did have a discussion regarding whether this proceeding is administrative or legal, and also what the as of right rights are of the developer to develop the site without further hearing by either the trustees or the Board of Zoning Appeals. We've had some exchange of ideas. It would really be helpful if we could reach some consensus about what rules apply. And I think maybe there's a division of opinion on that subject. So I raised the question now. I don't know how you want to address that.
I'll address the first one. It's an administrative hearing, as I said before. It's not a zone change. It's not a PUD, so it would be subject to judicial review, appellate review under 2506.
So we still have the other questions.
And I will leave that to Mr. Bickford to explain whenever the trustees would like him to do so.
It might be helpful to hear from him, not necessarily now, but at some opportunity where others, including ourselves, would have an opportunity to comment and ask questions to better understand that situation. So given those three housekeeping matters, we can now proceed to additional witnesses. And I believe the first witness is Mr. J. Janis, who I believe is here this evening. He's there. Mr. Janis, would you state your name and address for everyone's benefit?
My full name is Joseph Janis Jr. I live in 4462 Daffodil Avenue, Sycamore Township, Ohio. I've been a resident of that address for approximately 30 years. And keeping in tradition of what question was asked at the last meeting, my residence to the proposed development is 1.3 miles one way.
Mr. Janis, can you confirm that you were sworn in?
Yes, sir, I was.
Thank you.
I have been sworn in.
Thank you.
Proceed with what you would like to tell the
A couple issues here. At the trustee meeting of April 5th, 2018, in which I was in the audience, Ms. Kathy Miles, 7919 Kenwood Road, Apartment 3, Sycamore Township, Ohio, addressed the board in regards to the purchase of the building in which she resides and having to move. The building she resides is an apartment building facing Kenwood Road, which would be in this development from Capitol. At that time, she apprised all that the rent had been increased to $1,200 a month. She was on a fixed income, and I can speak personally as a person on a fixed income. Any increase in any fee is hard to absorb. I believe at that time, Law Director Miller said there had been no official approval of this plans at this time. Also, Mrs. Lakeisha Sherman Smith, a neighbor of Mrs. Miles, also addressed the issue. Both of them, as I recall, mentioned that they had just recently signed long-term leases appeared that they were gonna be having to move in the near future, and they were both against exorbitant prices, the exorbitant increase in their rent from the developer. Some of the, had a few other issues concerning this issue. Excuse me. The last hearing, the school superintendent, Mr. Phillips, he presented to you a petition with approximately, he said 300 signatures. The petition is, basically said the people who live there, or who signed off on it, lived in Sycamore Township. Personally, I don't know many of those people that signed it. One couple that have a business in Deer Park used the Deer Park address, which is in Deer Park School District, but they don't live in Sycamore Township. One household, the same person in the same handwriting signed 3 different names. And as a paralegal, and I believe in the legal field, that would be considered fraudulent on a petition. My school board sent a letter out to the community stakeholders. Correction, it was on school board letterhead from the developers, and basically it was enticing them. They said they would get $1.2 million check up front for air conditioning. Personally, as a citizen, as a resident of the Deer Park Community School District, I find this appalling that my school board signed off on it and allows a potential developer to sign off on this. They sent off an envelope requesting this petition come back to them, and people interested in signing it. I think that's very unethical. Next, as you're aware, I attend many school board meetings, particularly in the Deer Park School District, since I reside there. One of the issues important to this was a memorandum of understanding. At the time, our school superintendent stood up and said this is not legally binding. Well, as a paralegal, I can assure you that documents that are signed and voted upon at a public meeting, to my knowledge, I'm not a lawyer, this is not legal advice, but I believe they're legally binding. Some of the issues that I briefly highlighted were the township is interested in establishing a tax